Happy New Year, everybody. It's early 2025, and I am recording this video because I wanted to give you a little bit of context and insight around a new law that's going to be taking effect in just a few short days. I expect that this law is going to have a pretty significant impact on almost all stakeholders in real estate deals in the Commonwealth of Pennsylvania. So what I wanted to do was put on a short law school class, actually take you through the law just a little bit. You can kind of see how the sausage is made, how we take a look at these things on our end, and give you an idea of how this thing can affect you in what I hope will be practical and useful ways. And so without further ado, I'm going to actually bring this up. For the uninitiated, this is published by the Commonwealth, and this is a law that has come to be known as Act 52. It was signed into law by Governor Josh Shapiro last summer, and it takes effect January 4th of 2025. Basically, what this law is aiming to do is to change the rules around real estate wholesaling. And there's a reason why the legislature wanted to do this. So the first thing we have to talk about is, what is wholesaling? Wholesaling is when an investor or some other operator in the real estate market identifies a real estate deal and puts a property under contract for a certain amount of money with the intention of actually selling that contract or turning around and assigning the contract to somebody else for a fee. So to put that into an example that I think is easier to digest, what you could have is wholesaler John finds 123 Main Street and he finds the seller. The seller may not be initiated or may not know what their property's worth. So wholesaler John puts 123 Main Street under contract for $100,000. But the kicker is 123 Main Street is worth $200,000. So John turns around and sells it for $200,000 in exchange for a wholesale fee of $100,000. He then pays the seller their $100,000, and he hasn't really put a dollar into the deal. Those numbers are absolutely hypothetical. They have no basis. I just wanted to use them and nice round numbers in order to give you some context and framework around how this looks. It's often a lot less money than that, but nevertheless, it's popular. And what happens is sometimes sellers don't know what their properties are worth, and there's the risk, the perceived risk for abuse by wholesalers in the market. And one of the reasons for that is it's kind of been like the Wild West in a lot of ways. There's no licensure requirement up until January 4th, 2025 anyway, for wholesalers. So what Act 52, the act on your screen, is aiming to do is to actually expand Pennsylvania's law that governs real estate licensure. That law is called RELRA, which stands for Real Estate Licensing and Registration Act. And RELRA is the act that real estate brokers, real estate agents, similar kinds of real estate professionals are both bound in how they're governed. The failure to comply with RELRA can result in civil or criminal penalties in the event that someone, for example, practices without the proper licensure. And that's important for Act 52 because for my existing wholesalers out there, you may be doing what you did in 2024 without any issues, but all of a sudden on January 4th, you may now be out of compliance with RELRA. So there's some real impact here. What I want to do is talk to you a little bit about what the statute actually requires. And for that, I'm going to bring you down here. So the first piece of this is the definition of broker. And what they did was expand the definition of broker to include anyone who engages in a wholesale transaction. And so what that does from a legislative standpoint is what I just described to you, but now you're seeing the mechanism for it. This actually expands the umbrella of who qualifies to be required to be registered and licensed under this act. So all of a sudden, if you do the things you were doing as a wholesaler in 2024 without licensure, you're out of compliance, you've got a problem. This pertains to residential property. And then down here, we've got the legislative definition of wholesale transaction. Now, what I really wanted to show everybody is how this act actually aims to protect what are considered a vulnerable group, in as much as sellers who may be working with wholesalers and may not know the value of their properties are considered by the legislature to fall into that definition. So this lays out a mechanism whereby a seller can actually cancel an agreement with a wholesaler within 30 days of going under contract. That's really important because it creates a kind of uncertainty around wholesale agreements. It creates and reverberates, I think, throughout the market because it makes wholesale deals a little more difficult and a little more volatile in terms of their ability to get to close. So this act actually lays out how a seller can cancel. Now, they can cancel within 30 days if the wholesaler actually complies with the Act's requirements for a wholesale agreement of sale. And this is going to place an additional burden on wholesalers to comply. Specifically, there are disclosure requirements in here, including the disclosure that it's a wholesale deal. A lot of times that hasn't historically been disclosed. There is the right for the seller to obtain an appraisal or otherwise speak to another licensee under the Act, like a real estate agent or a broker. The Act really aims to empower folks who would otherwise maybe sell their properties for less than market. And if the wholesaler fails to comply by bringing their agreement of sale into conformity with the new elements of the Act, then a seller can cancel the entire deal up until the day of closing, not 30 days after execution. So wholesalers which fail to comply are going to have a whole lot of problems as they move toward the closing table. Their deals are going to start falling apart left and right. Now, why is this important? Why did I want to bring this to everybody's attention? I think this is going to reverberate throughout the real estate market. I'm not somebody who believes wholesalers are good or bad or indifferent. I think there's great operators in every segment and facet of the market. There are fabulous wholesalers. There are less than scrupulous wholesalers. But I think for all of them, this is going to have an impact because they're going to need to get the licensure to comply. They're going to need to actually comply with what's on their screen, with what's on your screen right here. And then I think some of the ripple effect down market is going to include things like an impact on the sellers, because sellers are now going to have to wonder whether or not the agreement that they receive complies with the Act. They're going to have to be educated about whether they have the right to cancel, whether they should cancel. Do they need to speak to a wholesaler? Do they need to speak to a broker? And then I think buyers who have relied, and there are innumerable investors, operators in the market who rely on wholesalers to source deals and bring them contracts. They also need to worry about, or at least pay attention to, whether or not the underlying contract that they are receiving by assignment or that they are purchasing, whether it complies, because they can set up expectations, expend costs, and they can bring themselves close to a closing, and then all of a sudden can find their seller decided to balk, or their seller issued a rightful notice to cancel the deal. And so it'll be interesting to see how this plays out in the market, but I think it requires some immediate consideration for almost everyone in the market. And so if you have any questions about this, if this comes up in your deals, if anything comes to mind, or if we can be a resource, reach out to us. You can find contact information on our website, and we'll look forward to being in touch. Happy New Year to everybody.